I'll kick off with introductions and our first set of questions. So welcome to all of you, and thank you very much for joining us today for this absolutely stellar panel discussion on a really fascinating set of intersecting topics around aviation and shipping emissions and nationally determined contributions. You will have had in detail the bios of our panel, but I'll say something very quickly about each of them before we get into the discussion. My name is Estelle Dehon KC. As you know, I'm a public law barrister at Cornerstone Barristers, and I've done a little bit of work on international aviation and shipping in the context of various legal issues around nationally determined contributions. That's the obligations that states have under the Paris Agreement to indicate how they're going to achieve net zero. We have with us today, as I've said, an absolute panoply of speakers. As we only have him for a short period of time, I'll introduce him first. We've got Payam Akavan, who is an international human rights lawyer and professor of international law. He acted as the legal representative to the Commission of Small Island States, COSIS, in its request for an advisory opinion to the International Tribunal for the Law of the Sea. And before I get to the discussion with you, I'll introduce everybody else. We've got Aoife O'Leary, who is a lawyer and economist with a deep environmental expertise. She founded Opportunity Green in 2021 to realise her vision of working closely with governments, other NGOs and industry around the world to seize really the opportunities around solving the climate crisis. Chris Lyle, who we have the benefit of his dulcet tones, but not his beautiful looks. But it's his tones that we're interested in today. Chris is the former Deputy Director of the International Civil Aviation Organization and currently the lead expert in aviation at the Tourism Panel on Climate Change, an independent science-based international collaboration launched at COP27. And last but most certainly not least, Damien Meadows, who played an integral role in drafting, negotiating and implementing the EU ETS, and now sits in the EC's Directorate General for Climate Action as head of the Commission's unit responsible for maritime and aviation international carbon markets. So no doubt the discussion is going to range far and wide. But if I can kick off just with you in the 15 minutes we've got you, Payam, can you tell us a little bit about the recent International Tribunal of the Law of the Sea advisory opinion and how it's relevant to today's topic, including questions around nationally determined contributions?
Thank you very much, Estelle, for inviting me to join in this very important panel. And while I'm most emphatically not an expert on the specific topic of the aviation and maritime transport sectors, perhaps my participation is relevant insofar as there is an urgent need for what we international lawyers call systemic integration and harmonization of the norms of international law as they apply to climate change. And this, in fact, is what prompted small island states at COP26 in 2021 to establish a commission of small island states, given the fact that small island states, which are the canary in the coal mine, if you like, of climate catastrophe, have become not just frustrated, but desperate at the lack of progress in the COP process. And of course, we now have approached the 1.5 degree temperature threshold in 2024 rather than 2100. And we are on target, according to the IPCC, to hit a catastrophic 3 degrees Celsius, which is essentially a death sentence for many low-lying island states that will simply cease to exist in the foreseeable future. So it was with that in mind, in the failure of the Paris Agreement and the scheme which it has established of unilaterally determined NDCs, procedural obligations with very little in terms of substantive obligations, the notable absence of enforcement mechanisms, that small island state conviction that much of what they are demanding is already part of binding international law. There were in parallel two efforts, both initiated by small island states. One was the Commission of Small Island States, which consists today of 9 members, 5 from the Caribbean, 4 from the Pacific, and it was the prime ministers of Antigua and Barbuda and Tuvalu that initially signed the agreement, which was then open to other small island states to join. That requested the advisory opinion from ITLOS in December of 2022, while in parallel, Vanuatu, which is also a member of the commission, initiated the procedure for the adoption of a General Assembly resolution to request an advisory opinion from the ICJ. Now, the very question of applying international law to climate change was both blindingly obvious and revolutionary, because we are familiar with the customary law principle of transboundary harm, that a state cannot allow its territory to be used in a way that causes significant, let alone catastrophic harm. In addition to other principles relating to the protection of the marine environment, specifically under the UN Convention on the Law of the Sea, which has very robust provisions on protection of the marine environment. And the power of the case that the Commission put to ITLOS was in its simplicity, that greenhouse gas emissions are a form of pollution, and therefore they trigger the exacting obligations to preserve and protect the marine environment under Part 12. And notably, that beyond abstract principles, those obligations must be interpreted in light of the uncontested scientific evidence that beyond 1.5 degree Celsius temperature rise, the risk of harm increases exponentially with every increment. And in fact, despite the skepticism that small island states could pull off such a historical undertaking, some 40 states and international organizations participated in the ITLOS proceedings. And in May 21st of this year, there was a unanimous among 21 judges advisory opinion, which for the first time set out in an interstate context the exacting obligations of states under UNCLOS. In parallel, in December of next year, the ICJ will hold hearings with the participation of an unprecedented 100 UN members and international organizations to look into the question of the obligations under general international law of states in respect of climate change. Now, the central question which emerged in the context of ITLOS, which is essentially the same question that the ICJ will have to address, is whether the Paris Agreement, the UNFCCC, and other instruments are part of a specialized regime qualifying as lex specialis, or in other words, is it sufficient for states to comply with their obligations under the Paris Agreement of submitting progressively ambitious NDCs in order to comply with their obligations under international law? And this goes to the attempt by the major emitters to fragment the international system, so that you have these self-contained regimes which are detached from the wider principles of international law. And ITLOS squarely rejected that argument. I think that is the most significant part of the ITLOS opinion. It is not enough for states simply to submit grossly inadequate NDCs and to say that they are in compliance with international law. Which brings me back to the point of systemic integration, which implicates also ICAO, IMO, the climate change regimes, but all of those have to be part of a coherent whole. And that is where I think the ICJ opinion, the ICJ having general jurisdiction beyond the UN Convention on the Law of the Sea, which was the limitation of ITLOS, the ICJ opinion, I believe, will play a very important role in synthesizing all of these disparate norms and regimes into a coherent whole. And just to end, it is notable that although the jurisdiction of ITLOS is limited and rather than 3% of it, and is the foundation of the climate system. So what ITLOS has already said in its opinion covers a very big part of the problem, if you like. And the ICJ is likely to give considerable deference to the opinion of ITLOS, including in respect of the so-called lex specialis or specialized regime argument. And I will end simply by saying that since, as we all know, international law cannot be enforced simply how it says to bring this jurisprudence to bear in the COP negotiations, in negotiations before IMO and ICAO and all the other arenas where one has to begin to change the conversation from unilateral, vague, inadequate commitments to a conversation based on binding international law. And I note, of course, that the ITLOS opinion specifically referred to the aviation and shipping sectors in determining the obligations of states. So thank you once again for having invited me, and I'm sorry if I cannot stay for the duration of this panel.
No, not at all. That was really fascinating. Thank you for such an interesting way of framing the discussion that we're about to have. And I know, Aoife, that Opportunity Green participated both by making submissions in relation to IDLOS, and you're making submissions in relation to the wider advisory opinion as well. Can you just pick up on what we've just heard and talk a little bit about how those two processes, the COP process and the Paris process, and the international process can interlink?
It's a very good question, Estelle, and I think it remains to be seen. It remains to be seen, but I think that the small island states were not engaged in an academic exercise. Certainly, they want to change the framing of negotiations, whether on mitigation and adaptation or loss and damages. And their demand is really strikingly simple. We want the major emitters to be bound by well-established principles of international law. So, as I said, we now have the ITLOS jurisprudence. We will sometime next year have the ICJ jurisprudence. And to that, one can add the European Court of Human Rights, the Inter-American Court of Human Rights. And the question is, how will an alliance of climate vulnerable, like-minded states, civil society, and other actors begin to use that the momentum created by that jurisprudence to change the framing of the negotiations moving forward. And as I said,
Yeah, and
as the expression goes, simplicity. Yeah. No, please go ahead.
And sorry, yeah. So, and Aoife, you've just come back actually from COP, so you're probably going to have some views on that and how that's whether that gravitational pull is working as of yet.
I think there is still a long way to go.
Sorry, I should be absolutely clear. That was a question for Aoife.
I'm sorry.
But I mean, Bram, I know you don't have that long to stay, so if there's something you want to add on it before I come in, absolutely please do. Okay. I mean, I would just say, I think the thing for me that the ITLOS advisory opinion has made crystal clear is that the obligation on states is to make sure we achieve the goals of the Paris Agreement. And we can't do that without also tackling aviation and shipping. And for a long time, a lot of both of the industries and also countries have said, oh, well, you know, it's not our responsibility to regulate aviation and shipping. They're international sectors. They have their own UN bodies. And those two UN bodies, ICAO for aviation and IMO for shipping, they will regulate it, and there's really nothing we can do beyond participate in those regimes. But what the advisory opinion has made clear is that's not enough. If those regimes are not bringing forth reductions in those sectors that are in line with the Paris Agreement, then those countries' obligations under international law has not been discharged. And that's, I guess, what we're working to try and make clear to those countries and also within those UN bodies. And at COP just last week in Baku, when I was there, I thought what was really interesting is the increased focus on these sectors. For a long time, again, they've just been kind of a footnote. They get mentioned in one of the kind of committee rooms as like, oh yeah, IMO and ICAO are progressing on those and we don't need to worry about them. But now, especially with the increased focus on climate finance, both sectors are historically undertaxed. And a lot of people, when they've been looking around going, where are we getting the climate finance from, have recognized that shipping and aviation are two potentials. And I will say the shipping sector, under discussions in the IMO, are moving towards potentially a levy with potentially revenues going to climate finance. There's a lot still to be agreed, and a fuel standard as well there. And we'll see how that plays out over the next year. Aviation really is not anywhere close. There is some great stuff going on at the EU level, which I'm sure Damien can talk more about, but really beyond that, there's very little happening in ICAO. So I think what we are going to see is just that pressure building. We'll see what finally happens at COP by the end of this week. But that will definitely play into both sectors next year, and people will be keeping a very close eye on them and revenue from both of those sectors as well.
Absolutely. And with that revenue focus, I think is really potentially going to be very interesting in shifting how these industries are approached. Pam, I'm very conscious that we've only got you for a little bit longer. So if there are any final thoughts that you would like to share with us, please do chip in. Otherwise, I'll hand over to someone else. But yes, if you've got any final views you'd like to share with us, please do.
None, Estelle. Thank you very much.
Super. So, well, if you just mentioned that there's Damien's likely to have views on what we've been discussing, and I'm conscious that we're having this discussion in front of a group of people who might not necessarily all be coming from the same perspective or work area. So in turning to you, Damien, I think I might just bring things back to a little bit of basics before you engage with what Eve has been saying. And can you just share with us a little bit about how international aviation and shipping emissions are regulated, the current position in relation to those emissions, and the way that states account for them under the Paris Agreement?
Thanks, Estelle, and good morning, afternoon to everyone. Absolutely. I mean, there's this myth, and it's a pervasive myth, and today's webinar is a great chance to put this hopefully to bed, that somehow states shouldn't take responsibility for aviation and shipping. And I'm sat here with the Kyoto Protocol as adopted. The second decision adopted back in Kyoto in December 1997. Decision 2 CP3 says states shall progress on the allocation of responsibility for these emissions to countries. So we've had options on the table. I think this is all set out in Opportunity Green's briefing. And the political challenge, of course, is it's inconvenient. Aviation emissions have more than doubled since 1990. Shipping emissions have increased. And so also because you have this unanimity rule, Rule 37 in the UNFCCC Rules of Procedure, it just takes Saudi Arabia or the US to say, sorry, we don't agree, and a COP decision hasn't been able to be adopted. And this essentially was the situation for 15, 20 years. Then the Paris Agreement said that developed countries shall have economy-wide commitments, Article 4.4, and developing countries shall move towards economy-wide over time. So for me, this was a big breakthrough. Europe, the 27 member states of the European Union have included aviation and shipping in their NDC to some extent. And when we talk to countries like China, China is not obliged by Paris to have an economy-wide commitment yet, but they may wish to move towards this over time. The Shanghai ETS of China includes shipping. The national ETS of China, Article 17 of the most recent law, says they will include aviation. So developing countries can do this over time, but Europe has lived up to the Paris Agreement with an economy-wide commitment, including some aviation and some shipping. But even today, I've seen statements from UN agencies or OECD bodies saying states cannot have aviation and shipping in their targets. It's frankly not a correct statement of the facts. And the UN Environment Programme has been much better here, sort of welcoming that Europe and others have taken responsibility for these emissions. There's a misconception of the legalities here, and there's also a political wish of some countries just to ignore these emissions. Europe wants ICAO and the IMO to succeed. We're working very hard for this. Maybe in a separate part of the discussion we'd go into that, but definitely I would agree with you and with Aoife about NDCs should be economy-wide. Paris commitments should be economy-wide.
Yeah, Chris, do you want to come in on this as well? Because there is certainly a very significant difference of opinion around what NDCs should and shouldn't cover, despite for some of us it being very clear, as Damien has just established, it being very clear what should be included. So what would you like to add to the conversation?
Well, I must say one of the reservations I have about my career when working for ICAO is that I was party to the decision in 1997 for the mitigation of international aviation emissions to be outsourced by the UNFCCC to ICAO, because ICAO's action is very seriously circumscribed by its regulatory dictate. And I can talk on the aviation front. I'm not a lawyer, and I'm an aviation policy wonk, but there are also some key differences, I believe, between shipping and aviation. Economic regulation, for example, shipping falls under the World Trade Organization. Aviation falls under about 3,000 bilateral air services agreements and some multilaterals. The regulatory authority given to ICAO is far less than that is given to the IMO. We have situations where integration of domestic and international is common in aviation, where the same airports are used. There's also a close relationship between international aviation and tourism is treated directly by the UNFCCC. But the separate treatment of international and domestic aviation emissions is a governance challenge for effective mitigation policy. The UNFCCC is effectively bottom-up through the nationally determined contributions, and ICAO is top-down. It establishes standards and recommended practices which states try and follow. And you can compare here the failure of the Copenhagen COP versus the Paris one, because the Copenhagen failed because they were trying to do a top-down process, whereas Paris was the bottom-up. And ICAO cannot do that. There are certain articles, I won't mention them, but there are a few articles of the Chicago Convention which established ICAO, which basically say you have to have equal application to each state, which means that you're ending up with the lowest common denominator. The filing of differences of ICAO is not the same. It has no regulatory power. A state can object to a difference being filed to an ICAO standard. And in most cases, nothing happens as a result. In some cases, if it's a major security or safety issues, for example, the United States would perhaps not allow the carriers of that country to fly to the United States, but it's it's much lesser on environment. The other thing is that the UNFCCC is dealing with greenhouse gases. ICAO is still dealing only with carbon dioxide. In 1999, ICAO requested a study by the IPCC on aviation in the global atmosphere. And there, in that study, the IPCC pointed out that there was more than CO2, there was NOx, and there were other greenhouse gases. Now, ICAO, 25 years later, they've just held last October a symposium and have said, yes, non-CO2 are a problem. But since we don't know how big it is yet, we're not going to do anything about it until we know how big it is. So it's untouched. So that's another reason why UNFCCC is better. I think that, you know, I don't know if you want to go right now into the issue of the parallels between the filing of NDCs in UNFCCC with something called the State Action Plans. ICAO, there are parallels.
I think we'll leave that beautiful, juicy topic for a second, and I'll just pass over to Aoife to say something also about the IMO in this context.
Yeah, well, I might just add one thing on ICAO before I move to the IMO, which might illustrate the difference as well from what Chris has said. I think one key importance for me, I think all of the governance issues that he's mentioned there, but for me, the key governance issue is about how the members actually come together in ICAO. So all the members of ICAO only actually come together once every 3 years for the assembly. Otherwise, basically everything is done through the council with some committees as well. But if you're bringing together all the members of ICAO, it's really only once every 3 years, which really doesn't give a lot of opportunity for example, small island states to really set the direction or tone of ICAO at all, which is where the contrast, I think, is with the IMO. You know, and these are just kind of governance accidents. Well, accidents is probably the wrong word, but the way that they've been set up for a long, long time, it's not anything to do with climate, but it's just kind of, luckily, this is how it's been in the IMO. Now, to be clear, in the IMO, there's a lot of governance issues. I don't want to paint too rosy a picture, but I will say, especially now as we get deep into the climate negotiations, all states have 3 or 4 times a year where they come together, and that now has meant that especially the small island states have really driven forward a lot of ambition, which has been really, really excellent. And what we have seen in the IMO is quite a step change because of that leadership from especially the Pacific Islands, which have really stepped up and just made clear, you know, this is an existential threat for them. And over time, then the IMO and the governance of the IMO has actually responded to that. For sure, at first it was very, very slow, but now there is an agreement that in 2025, we will get an economic measure, which basically means there'll be some kind of charge on the greenhouse gases from shipping and also fuel standards. There are a lot of details to be agreed on both, but everyone, the timetable is clear. It's going to happen by spring next year, and then it will come into force in 2027. So we'll see how ambitious that is and exactly what it means and where the revenues will go, and all these questions are definitely still to be decided. But I think it's just really important to come back to that point. And I think that Priam made at the start, you know, really, if you look at the international legal regime and the governance, it's very tricky and it's hard to work through, but it's been small island states that have really navigated through that and shown leadership. And that's very clear in the IMO through the ITLOS advisory opinion, but unfortunately has not yet been reflected in ICAO. But the next ICAO assembly is in September 2025. And I would be hopeful that maybe we'll see small island states come along to ICAO and try and do what they can there as well. But we shall see.
Yes, it was one of the key parts for me of the ITLOS advisory opinion, where there was that recognition, direct recognition, clear recognition of the existential threat posed by climate change. And Priam mentioned right at the very beginning about the way in which there was a very significant recognition of and reliance on the science. And that too, I think, is going to be important, kind of looking at this from a lawyer's perspective. The way in which that opinion was approached, both in terms of the science and in terms of recognizing the existential nature of the threat, I think also will exercise that gravitational pull, hopefully, on other courts when they're looking at climate change related matters. Before I go back over to Damien, but just before I'm going to do that, I noticed that we've just got, I think, a bit of time left. So in case there's any final thoughts that you want to share with us, if there's anything you want to say about IMO, ICAO, or anything else, you'd be very welcome. Otherwise, I'm going to move over to Damien.
Thank you, Estelle. And I will unfortunately have to leave now, but I think it's a brilliant idea to assist small island states to participate in ICAO and IMO deliberations. But having worked with them, one of the biggest issues, of course, are resource constraints. Tuvalu has a population of 11,000. So one of the big issues is whether government, civil society, and other organizations are in a position to provide resources to the Commission, which can then go on to assist small island states. So there are all sorts of opportunities to explore collaboration.
But a hopeful note on which to end. And thank you very much again for your participation today. Damien, just coming over to you in light of the discussion that we've been having, obviously, if there's anything else that you'd like to add in relation to ICAO and IMO, but moving forward beyond that, there is that tension that's often brought forward by states to say that they don't want to take action in their NDC process, for example, because that's somehow going to undermine, or it's somehow going to mean that they can't also achieve what's required at the international level. So maybe you can also talk to that as well. Oh, and you're still on mute.
Sorry. Thanks, Estelle, and I was muted. So this is a misunderstanding as well. I mean, if you look at the history of ICAO action and the progress we've been having in the IMO, this has been very much influenced by Europe and others actually taking action. And taking action on climate change is kind of what we need at this point in time. We've been needing it for quite a while. So it's not like one impedes the other. And if you look at what ICAO says to the UNFCCC, it's sort of, we don't want people competing with us, we want to have the lead. Europe wants ICAO and IMO to lead action, to put into effect effective regimes. Here, the IMO, I agree with what Aoife said, I'm very hopeful for the IMO making some progress. On ICAO, I still remember back in 2004 when they ruled out having a treaty. They said it was sufficiently unattractive, it should not be pursued further. And I think governance is absolutely key. Europe takes its responsibility in the emission trading system for its fair share of shipping emissions. We've studied well the UNFCCC options, and it's route-based, whereas what you have in ICAO is a company-based system where American Airlines belongs to America, Aeroflot belongs to Russia. That system works if Putin applies the ICAO system. It is apparently mandatory for Putin to do this in 2027, as it is for China, who have notified a difference, who've said it's immoral and unfair to China given per capita emissions. And for the United States, I think we'll be seeing a change of administration. There would be a need to adopt legislation in Congress. I think that's undisputed. So Europe, we are the most multilateral region of the world. We've implemented ICAO's scheme in national law. But we are going to see in 2027, if other states don't do this, it will bring all kinds of distortions and risks, and it could essentially fall apart. So it would be good if small island states are there speaking up on this, taking part. But I would say it kind of depends on the actions of the Chinas, the USs, the Brazils, and the Russias of this world, whether the ICAO scheme actually works more broadly than Europe or not.
Yeah, I mean, absolutely. That raises a number of tricky questions, and maybe we'll have an opportunity to discuss with participants who, of course, are able to ask questions in the Q&A function, so please do that as and when you'd like. And we're going to hope to have maybe 10 minutes at the end for picking up questions arising from what the panel said, or anything that you're interested in asking on this topic of our fantastic panelists. Chris, I'm going to circle back to you and pick up the juicy topic that I parked for a little while, which is that interaction that in relation to ICAO between NDCs and state representations, and how that all works.
Yes, thank you. And can I just say, in response to Damien, while there's an apparition that it's mandatory to commit to CORSIA after 2027, in practice, I'm not sure it's going to happen. It's only a question of disagreeing with the standard, and China and Russia in particular placed reservations at the last assembly on the whole assembly resolution. So I'm personally not convinced that you're going to see, it's certainly not mandatory in terms of legally binding. Yeah, concerning the submission of NDCs and so on, we all know that few parties currently incorporate international aviation emissions into NDCs, basically EU and Switzerland. And they only at present apply within the EU and Swiss territories, because beyond those they've weaseled out and are just following the ICAO process. ICAO that has a parallel to submitting an NDC. In 2010, ICAO launched the so-called State Action Plan Initiative as a means to provide states with the capacity and tools to take action. It enables all member states to establish a long-term strategy on climate change for the international aviation sector. But there is no clearly definable link between NDCs and the the state action plans. But a number of states, and I have backup for this, apparently consider their state action plan as a surrogate for including international aviation in their NDCs. States are invited to update their state action plans every 3 years. Now, state action plans have been reported to ICAO by 148 states as of today, and they represent 99% of global air traffic. There is a difference, though. The nationally determined contributions are public, and they define a commitment to what you're going to do. A state action plan does not require any commitment. It imposes no obligation and is considered confidential unless the state grants specific permission to make it accessible. 103 have done so. Of the 45 missing ones yesterday, I did note that one of the missing ones was Russian Federation. Anyway, I think, obviously the state action plans cannot really be considered as a surrogate. They have no binding commitment to them at all.
Certainly, and both in the international arena and even domestically, we're having a number of issues where these types of voluntary arrangements are butting up against how we address the extent to which emissions are permissible. I mean, the discussion with CORSIA takes me back to the work that I was doing for local communities in relation to airport expansion in the United Kingdom, and the extent to which we put forward evidence to say CORSIA is not something that this decision maker can rely on as capable of regulating emissions going forward in the way that's necessary. But it's a tricky argument to make, and it's yet to be accepted. So, we'll see going forward. Aoife, if I can come to you just about a number of the things that we've been talking about picks up really how complex it can be. It can be sort of problematic for systems to be talking to one another, and that there's definitely going to be complications in including or accounting for international aviation and shipping emissions in NDCs. But can you talk us a little bit through that and how those might be able to be overcome?
Absolutely. It's always a little bit funny to me when I speak to states about including, double counting, it's complicated. And I'm like, Well, no one's accounting for them really at all yet. So, you know, I'd love to get to the place where they've been double counted and double regulated and everything. That sounds like the dream to me. I long for that day. But I understand that it is a genuine concern. And I think some of it stems from the fact that because discussion under the UNFCCC never actually, there was various options discussed as to how we would divide international shipping and aviation between countries, never came to a conclusion. We had the Kyoto Protocol saying working through ICAO and IMO, and now we have Paris, which does not specifically mention aviation shipping and clearly says economy wide. But what we still have then is a rule that basically says if you sell bunker fuels, which is the fuel for shipping and aviation, you kind of record that as you report back to the UNFCCC. So that has meant some countries are concerned that if they regulate or even account for flights, for example, that depart their territories, which is how the EU does it, then that will conflict with potentially the bunker sales, which doesn't always account exactly. But I think what is very clear is that the EU has done it and it's not been an issue yet. I think what we can see is it makes sense to do it on the basis of departing flights for aviation, because that is quite a clear measure and it's quite an easy way to keep track of the flights. And you've got quite a lot of different legal hooks that you can use, whether it's an emission trading system and fuel mandate as the EU has or others. Similarly, on the shipping side, the EU is regulating on the basis of half of all the journey from the EU and half of the journey to. And there's some really great graphs that like show that clearly. But essentially, if you are coming from a port outside the EU, then half of that journey and then half of your journey onwards are regulated by the EU. And again, that makes sense in terms of how much the particular country is taking in terms of trade and other ways. And really has not led to any issues so far. The concern can be alleviated relatively easily. You can make that clear in submitting your NDC when you do say this is what we're regulating and this is how we're accounting for it, etc. So I would suggest that it's quite an overblown concern that has not really been shown in the real world at all. So I would say that it's one of those things that unfortunately the industry and some countries who do not want to regulate whip up as a false kind of legal blocker, but really it's political. And I do also just want to say here as well, Damien has mentioned earlier the great advances of the EU, which has led to the IMO doing what it has. And I absolutely agree with that. I think that is really what countries need to think about when they're thinking about including these emissions in their NDC. It's not that it will block international progress, it's that it will spur international progress. And that is really exciting. Like we've seen the UK and Switzerland include international shipping and aviation in their own carbon budgets internally, but they haven't actually put it in their NDC yet. So hopefully we will see that change over time. But I think there's promising changes going forward, but it does come back to the legal obligation internationally is to regulate both sectors in line with 1.5. Neither ICAO nor the IMO yet are doing that. So until they do, that legal obligation still falls on individual countries to do that. And really, one of the best ways to do that is put it in the NDC and then regulate it.
Yeah. So Damien, I'm going to come to you next to pick up exactly this set of questions around how what the problems might be with putting it in the NDC and also how those can be overcome. But I just note in passing that it's interesting that the United Kingdom has made the decision, despite accounting for international aviation and shipping emissions in the 6th carbon budget, not to include them in the NDC. And one of the results of that is that there's in its updated NDC. And so one of the results of that is that the 6th carbon budget requirement for emissions reductions by 2035 is different from the NDC requirement by 2035. The NDC requirement is stronger, but that's partly to give this headroom in relation to international aviation and shipping emissions, as I understand it. And it was interesting to read the Climate Change Committee's reasons for why they still, despite having taken the step to advise that international aviation and shipping emissions be accounted for within the UK's carbon budget, they haven't taken that step in relation to the NDC. And we'll see whether other approaches by other entities, in particular the EU's approach, might change that going forward. But anyway, Damien, I don't know if you want to pick up on anything about that, or if you want to talk about the technical ways in which an NDC can actually manage to address aviation and shipping emissions.
Sure. I mean, I think on that, I mean, I put in the chat to Chris, I mean, it's a narrow point, but Europe has taken responsibility in its NDC for the departing flights from the EU 27 towards the UK. But I'm glad we're getting into the nuance. I mean, Europe has carbon pricing for its fair share of shipping emissions, but we haven't included all that fair share which is priced into our NDC as yet. I probably should have mentioned in my earlier intervention, we always have review clauses. I was an aviation lawyer in the 1990s in the UK working on aviation emissions. It possibly isn't matching the speed of the action we need to tackle climate change and avoid catastrophe. And if we have that action, of course, we'll be having review clauses all the time. After next year's agreement in the IMO, there's a review clause in European legislation. And this is where, I mean, I can imagine there could be pressure to have the same scope that we carbon price in Europe's NDC. In its resolution for Baku, the European Parliament said the UNFCCC should make progress on allocating shipping emissions. That's a discussion which has kind of been left hanging since the early 2000s. I mean, I personally agree very much with what Chris said on ICAO. There are legal studies, positions of China and others. I think you've got a really important date in 2026, 2027, because if there is a UN agency which designed a system which doesn't work, and it doesn't work because Chinese emissions are 1/30th per capita of American emissions, and the Chinese therefore consider it's unfair, then frankly, I think there should be a bit of an examination of what went wrong. And this examination would probably be accompanied by pressure to actually have states take some responsibility for this. I think for the UK, our aviation emissions approaching 10% of national emissions. It's getting quite high in countries in the developed world, part of this global inequity in terms of flight emissions. But I very much see this coming up in the next 2-3 years, because Europe, I mean, we limited the scope of our emissions trading system now for 15 years for ICAO to succeed. We want it to succeed, but it's dependent upon countries outside of Europe to put laws into place. And that hasn't been the situation yet outside of South Korea and I think Canada.
Yes, it's interesting what you say about recognizing the way in which systems fail. In fact, I happened to be reading recently an interview with Cristina Figueres about why she thought the Paris agreement came into place in the first place. And she said what she thought was because of the significant failure at Copenhagen, and how there had been an analysis, a very open, very honest analysis of why there was previous failure in order to see what to do to achieve future success. And it may well be that with ICAO in particular, but with both the international mechanisms for addressing these emissions, a little bit of failure analysis would be quite useful. Chris, I don't know if you want to add anything before we head over to questions. We've got one in the questions so far, and I'm sure there will be others. But Chris, is there anything you'd like to add?
Yeah, I would like to say that I do think that including international aviation emissions into the NDCs is absolutely fundamental, irrespective of the current roles of the UNFCCC and ICAO. At present, there's a very limited commitment by states beyond Europe, and that is beyond Europe for Europeans and to the rest of the world, is to follow the provisions of ICAO's carbon offsetting and reduction scheme for international aviation. And that's a complex form of offsetting. Despite including the word reduction in its name, it's not aimed at reduction of emissions. It rather sets out to achieve a goal of carbon neutral growth, currently above 85% of 2019 levels. This means that carbon dioxide below those levels is untouched and continues to be churned out annually without any redress at all anywhere, including international aviation. The NDCs would respond accordingly. And I think that alone is a reason why international aviation should be included in the NDCs.
Excellent. Thank you very much. And just picking up on this, so the first question that we've got is from Ingrid Gabbe from Hausfeld, who has had to head off, but she's asked an interesting question, which is, we recognize that diplomacy and governance is ultimately important, but we as lawyers especially think about those legal avenues to nudge the process along. And obviously, the ITLOS opinion and the ICJ advisory opinion might assist. But coming out of what she says, what do you think, and I'll ask Aoife this first, what do you think are the avenues for legal ways to encourage or require states to shift their opinions about what should go into the NDCs and to start accounting for international aviation and shipping emissions through their NDCs?
I think the specific legal avenues to me are mostly actually around the industries themselves. So if you can have the industry actually going to their country representatives and saying, please actually get a global regulation, please make it effective. I don't want to have to be either a first mover or being sued because I'm not moving at all, then we'll see progress. And so that's definitely one of the things Opportunity Green is looking at, is how do we tackle the industry itself, and either like challenge the laggards or also work with the first movers to get them to understand the importance of regulation and really become the advocates themselves for really effective regulation. So that to me is the key legal avenues that we need to see working.
Yeah. Damien?
I think sunlight and focus, transparency. I mean, if you look at the statements in Baku of the ICAO Secretariat, it's basically saying there should be no fossil fuel pricing and no use of this to help developing countries. So I've also heard what Aoife has said about sort of the positive discussions in Baku. But when you have a UN agency saying effectively the contrary, then you have a governance issue. And frankly, when aviation emits 1 billion tons, shipping emits 1 billion tons, more than 150 countries put together, this deserves so much more focus in terms of, are they doing an effective job? Because it's growing as a percentage of Europe's emissions, aviation shipping. We just had a 16% year-on-year reduction in the power sector through massive expansion of renewables, improvement of energy efficiency. And what you're being left with is these two sectors, along with agriculture, are some of the major remaining emissions. And so, yeah, I think transparency, increased focus, and we are coming up to these key points for IMO, a positive one next year for it to deliver in 25. And for ICAO, if we don't have laws in place, it's traditional to have a law in place before the legal commitment on US airlines. So presumably they'd have to legislate in 25 or in 26 if there's a law in place for 27.
Yeah. So one quick last question before I ask for final thoughts, and it's from Elizabeth Vane, and it might be a general question about NDCs and why they are not aligning with the remaining carbon budget established by the IPCC for staying below 1.5 degrees. That's a big question. I don't know if anybody wants to have a go at it. Damien, you seem very keen, and then Aoife.
Yeah, I think I'm keen because Europe, we were a huge supporter of the Kyoto Protocol. I drafted the ratification instrument. We're very comfortable with actions which do align with the IPCC. Paris was a huge achievement, but it needed to be approvable by the United States without going through Senate. This limited it to being bottom-up pledging. And that bottom-up pledging, I think, is one of the sources of it being inadequate. it's a huge challenge. I mean, what Chris said about the non-CO2 emissions from aviation is absolutely right. Europe's offering money to anyone who wants to reduce these. We've introduced monitoring. We've had US airlines oppose those monitoring rules, saying it's extraterritorial to look at non-CO2 climate impacts over the Atlantic. The scientific truth is that's where those impacts are largest, night flights across the Atlantic. We've put that back to 2027 in deference to the strongly held views of US airlines, but there are plenty of pressures not to have NDCs in line with what we need scientifically. It's scary in terms of where we go because of that, but that's the Paris setup, and it needs Europe and countries outside of Europe to be making stronger NDCs, absolutely.
Yeah, Aoife?
Just because I know we're pressed for time, I would point to a study from the International Council on Clean Transportation, which is really interesting on aviation, which looks at the current aircraft that exist and the order book and basically the locked-in emissions and whether we can meet 1.5. And the answer is maybe if we really drastically do absolutely everything. And so that kind of shows already just how difficult it is. But again, coming back to that, why it is so important for countries to put it in their NDC as well as everything else. Like, we cannot just rely on ICAO.
Yeah. Chris, any final thoughts before I bring everything to a close?
Yeah, just a couple. It's ironic, isn't it, that ICAO puts that statement that Damien mentioned to the COP about the funds not going to developing countries. But of course they do through CORSIA. So basically it's saying it's okay if you do it through us. But I think one of the real concerns I have in terms of getting some change, and maybe the most recent discussion we've just had would be a good idea to get some academics doing a study about the relationship to the carbon budget. But one of the issues I have is that ICAO is heavily influenced by industry. They have offices next door to the headquarters building of ICAO. They're there all the time. Every decision that ICAO has taken, whether it's carbon neutral growth or CORSIA, was preceded by a decision by IATA. And at one point I was told by an ICAO council member, when I was saying, well, where's your long-term goal? He said, we're waiting for IATA. So I think, there has to be some kind of legal process, otherwise nothing will happen.
Yes, and that picks up exactly what you were saying, Aoife, about the industry needing to shift. And if you've got legal mechanisms nipping at the industry's heels, then that's really where we need to be focusing. Well, this could go on. And no doubt will in other fora on other occasions. But it just falls to me to thank all of you for coming to watch, and to thank our absolutely fabulous panel for expressing yourselves with such clarity and with such passion. It's a real pleasure. I think going forward, one of the key things that we're going to be having to address, not just about the resistance to these being put within NDCs, but also we're going to have to start to address the narrative shift when it's recognized more and more that 1.5 degrees is going to be overshot, and what that's going to mean for the way in which we account for emissions. And certainly my perspective is that overshoot or not, it's plain that NDCs have to be 1.5 degree aligned, and that they have to take into account international aviation and shipping emissions. Otherwise, whatever the overshoot is that we're looking at the moment, it's going to be much worse. And we know that there are catastrophic implications for every small part of a degree of warming. But we don't want to end on that. We want to end with the positivity. Which is that it's clear that there are very engaged and clever people working across the piece on this. And we look forward to having the opportunity to discuss this with you in a bit more detail on further occasions. Thank you very much indeed. The recording of the webinar will be available to those who came and those who signed up but couldn't be with us. So if that's you, we hope you've enjoyed watching the recording. And wherever you are, whatever the day is, whatever the point of the day is for you, I hope you have an excellent rest of the day. Thank you very much for joining us, and goodbye.
Thanks everyone. Bye.
Thanks, Estelle.